My name is Edmund Jordan, and I'm proud to serve as the Vice Chair of the House Insurance Committee. As he said, I've been in the legislature since 2016. The district, I always say, I have the only House district in the Baton Rouge area that covers both sides of the river, so it gives me, I think, a unique perspective on the Baton Rouge metro area. So I'm certainly happy to and privileged to do that. It's an honor. I know we're here to talk about insurance today, and just to let you know, between the House and the Senate, we have 81 bills. 81 bills that we have to hear, and that may sound like a lot, but in actuality, it shouldn't be very bad because a lot of those bills are duplicative. We're going to have some issues on the health insurance side. Again, like always, we've been dealing with pharmacy benefit managers, pharmacy service organizations. We have a bunch of issues with surprise billing. Everybody who goes to the hospital, you get these bills, you think you're going to be charged one rate, and then you get that bill in the mail and it's something else. So we're dealing with that. But the biggest issue I think that we're going to deal with this year is, no surprise, it's tort reform. And so I just said earlier, and the Commission and I sometimes disagree on this, and I'm sure we're going to probably disagree a little bit today. But we've identified the problem. The problem is that we have some of the highest rates, auto rates in the country. Nobody can dispute that. We can look at what we pay. Everybody who pays that bill, whether you pay it monthly, quarterly, yearly, biannually, however you do it, we know that we have some of the highest rates in the country. The real dispute is, how do we solve that? And I know there are some folks that think that, like the Senate Chair, Kurt Talbot, who is a colleague of mine and a very good man. I served on the Insurance Committee with him last year. He had an omnibus bill that tried to attack several issues, and frankly, I did not see eye to eye on all of them. But let me go through a couple of them and tell you where they are. One we talk about is a jury trial threshold. Now, we understand that, and just so let me back up for a second. In Louisiana, if you want to have a jury, the amount in controversy has to be above $50,000. Now, that's one of the highest in the nation. Some have no jury trial threshold. Some have 5,000, some have 15,000. But they want to lower it, and I'm not sure what the number is going to be ultimately, but let's just say that number is $5,000. So any controversy over $5,000 would go to a jury, or at least be eligible to go to a jury. Well, I don't think, and the task force, there was a task force last year that dealt with this. Task force doesn't say that that's going to affect insurance rates at all. What I think it would do is actually make it more expensive. And so you say, why is that? Because your litigation costs are going to go up. Anytime you take something to trial, litigation costs are going to go up. Litigation trial is expensive. You have to pay for jurors. That means we're going to have more people sitting in a courthouse instead of being at work. But most of all, what I would tell you is it's going to clog up the court system. Like right now, I do try cases. I am an attorney. I do try cases for a living. I can tell you right now in East Baton Rouge, if you file suit today and you want to take that case to trial, you're going to be waiting at least a year, if not 18 months, to get that to a trial. And that's even on a bench trial. So if you're going to look at lowering the threshold, you're going to have more people there. So it's going to take even longer to get to trial. So what does that mean? That just means it's going to be longer before somebody gets justice one way or the other. We have some other things that deal with direct action. In Louisiana, you can sue excuse me, the insurance company directly. You don't necessarily have to name the individual defendant. Well, some people say, well, if you know that the person has insurance, that's going to drive up the cost, and the jury is going to be more inclined to award a larger amount because they don't feel that the person is paying it, but the insurance company is paying it. You know, I look at it like this. How many in this room have insurance, just by a show of hands, auto insurance, right? All right. How many of you know that auto insurance is mandatory, that it's compulsory, you have to have it? You do, right. So I think it's insulting the intelligence of a potential juror to say that even though we don't name an insurer, that we're going to believe that that person who's being sued for an auto accident doesn't have insurance, whether you name them or not. So I don't think it makes that big of a difference, right? We also have a bill that deals with prescription. Now, I am in favor of extending that. Right now, we have a 1-year prescriptive period. So that's the time that you have to file a suit. So 1 year from the date of the accident. Most states have 3 years. Some states have 2 years. I think in the bill, they want to expand it to 2 years. I think if you give people more time to settle these claims, then it does just what we talked about with the first issue. It reduces litigation, and so you don't have that litigation issue. If we have more time to resolve claims, then I think people could settle them outside of court, which is a cheaper way of doing it, and I think that could reduce some things. But the biggest issue, I think, is really collateral source. And so without getting too deep in the weeds, what happens is when you have your health insurance, and if your health insurance pays for your bills, you get to sue for the entire amount of that bill. And what the court says is because you've paid your premium, that you get the benefit of that. That's a collateral source that helps you. And that the tort fees that are the person who caused the harm does not get to take advantage of that. Some people think that drives up the cost of settlements or awards. I don't necessarily think that. I think if I pay that bill every month, for health insurance, and health insurance is not cheap, that I should get the benefit of that because you're not going to give me my premium back. So you really disincentivize people from having health insurance. But without getting to that philosophical deal there, that's part of what we're talking about. So that is most of the package. Now, I've told you what I don't think is going to reduce auto insurance. So let me tell you what some of the things I think would reduce auto insurance. Here in Louisiana, we use credit scores to determine some auto insurance rates. Now, there's a correlation, the industry will tell you, between poor credit scores and accidents. And they say that if you're reckless with your credit, then you're going to be reckless on the road. Now, I don't necessarily buy that. That's not my position. And so I would tell you, I don't agree with that. I think what we're doing, in effect, is we may have people with poor credit, and we're a state with a lot of poverty. We're having people with poor credit that may be good drivers. We're keeping them out of the system. And what I do is very simple. I equate it to health insurance. It's like the Affordable Care Act. It's like any health insurance model. What you want to do is get healthy people into the system that aren't filing claims but paying premiums to subsidize for the people who may be older or unhealthy that are filing claims. And so we reach this happy medium. And so what I would suggest to you, and others have suggested, is that you get good drivers into the system, whether they have poor credit or not. But if you get good drivers into the system who aren't causing accidents and who aren't filing claims but are paying premiums, then it's going to lower the rate for everybody, for those who even file claims. So I think there are some things that we need to do. We need to do away with this so-called widow's tax. And I would somewhat agree with the commissioner on this. It's married drivers versus single drivers. But I think that if somebody is married and their spouse dies and they suddenly become single, I don't think that's a reason to up their rate. We have people that are in the military that are deployed, and they may be gone for more than 6 months and don't need insurance. So they may turn in their plate, do everything that they need to do, but then when they come back, if they say, well, I haven't had insurance for 6 months, well, then they're taxed or given a point for that. So I think we need to do away with some of those things, and there are some bills there to do away with that. But at the end of the day, we need to lower the rates. There's no doubt about it. And so I would not dispute that. I would not sit here and tell you that we shouldn't do that. I can tell you for truckers, and I live in look, it's, sugarcane drivers. We know people are doing harvesting. I know school bus drivers. In the last 3 years, I think insurance on school buses have gone from basically $8,000 a year to $18,000 a year. That's ridiculous. We should not have that. And I would not defend that. And so I want to be very clear, that is not my position. Again, we have identified the problem. This is not one where we have our head in the sand and say that the problem does not exist. I think it does exist, but I think we need to find some solutions. And quite frankly, let me just say this, because I know some of my friends who may be attorneys out there may not like it, but I think we do need to rein in attorney advertising. I think that plays some role in the insurance rates indirectly. And again, I don't have data on that, and I usually like to have numbers to support what I say. And so I don't have any direct data on that, but I do feel that plays some role in some of the rates, the high insurance rates that we pay. And so I do think my brethren of the bar are going to have to take a look at ourselves at some point and say, okay, how do we deal with this, short of some of the measures that are being proposed this year. But with that being said, I'd be happy to answer any questions at the appropriate time, but I want to certainly give our great staff an opportunity to introduce themselves and talk about the package of bills that the department has.
I think what we're going to do, according to Crystal's format, is just each of us run through our bills in order of the slides here. I'm Warren Bird. I'm Deputy Commissioner for Property and Casualty Insurance, and I've got 6 bills to go over with you today that are in the package.
Warren, your microphone.
Is it on? Just pull it. Okay, my bad. I'm sorry. Thank you. This is our presentation here. Okay, here are the property. That's it. Okay, this is my bills that I have for property and casualty. House Bill 170 by Representative Hollis is a bill regarding the workers' compensation terminology. In our code presently under 22:337, there's some old language that talks about a Louisiana domiciled independent claims adjuster. We have fortunately morphed through the years. We now have resident or non-resident, so we're changing that from no longer Louisiana domiciled to, say, a resident license. And also to now claim that it be an actual workers' compensation adjuster rather than an independent claims adjuster. So no particular issue, I think, there, just updating the nomenclature of the language. Senate Bill 72 by Senator Gary Smith is a bill we've looked at for several years. We right now have in our, for you insurers who file the forms with us, as you may know, we have several different categories and several different charges for what you have that you have to pay for in a form filing. Rates do not have fees, but forms do. They range from $0 to $25 to $100, and given the multiplicity of items that may be in a particular form filing, you have to make sure you have your calculation correct. Quite often they're not. Sometimes there's overpayments, sometimes there's underpayments, and that can delay the process of getting your forms into the review process at the Office of Property and Casualty Insurance. What we've done here is come up with a one filing fee for whatever it is, and it's going to be $50. So that's I think it'll be a great savings. We've looked at it from a revenue issue. It is revenue neutral as best we can tell from what the last 2 years would be based on money we bring in and number of filings. So if you're a carrier out there and you're trying to, in the past, look at how many endorsements you had and base policy forms you had and add it all up, no longer worry about that. Whenever you hit the surf button to make your filing, it's $50. That's all it's going to be. So I hope that's a very simple way to look at it. Senate Bill 119 by Robert Mills is a liability limits and defense cost bill. Right now we operate under an Attorney General opinion that provides with us information on how we can treat various filings, and mostly those commercial or professional filings that deal with defense costs being allowed to be within the limits of the coverage. We operate well. We have a set of criteria. What we want to do is take that AG opinion that we currently utilize and simply put it into statutory form, and that's really what this bill will allow us to do. It still will have no defense cost in the personal lines arena. Commercial auto would have no defense cost, a CGL policy, things like that, PPA. Those are ones that relate to paying to a victim, so we don't want to look at that. But other type of coverages like directors and officers, E&O coverage, things of that nature, some of that may need to have defense costs within the limits, and we'll look at that as we do now with the AG opinion. We'll just simply have a statutory basis for that. Chairman Talbot is bringing this for us. I believe we have a number. I don't have it for you right now. This was Act 212 from last year that required commercial auto carriers to file with us information based on zip code and or parish. We found out that there were a number of carriers. They were allowed to exempt themselves if they didn't have the data on that level, and most of them, or a lot of them, did not. So it's become very much a situation where the data is not providing what this bill was intended to provide. So we're going to look to go ahead and repeal that and unburden the commercial carriers with that obligation. Senate Bill 195 by Senator Bernard. This is a situation in our code right now at Section 887. There is provision and that deals with just property and casualty insurance and the notice of cancellation and reinstatement. There's a specific provision, subpart I, that says when you have a property policy and you've issued a notice of cancellation, if that policy is later reinstated, you need to give the same notice of reinstatement to the same people you gave the notice of cancellation to. Deals with, as you might expect, a homeowner's insurance, and they got a loan, and the mortgagee wants to know, okay, you got the notice of cancellation, but you did your work, you got it reinstated. I don't need to go out and force place a policy. So they get notice of reinstatement, and they're all's good. We don't have that same requirement on the casualty side. So all this says is that if you issued a notice of cancellation to 3 people because of a casualty policy that was going to be canceled, that if you reinstate that policy, you send the same 3 people the notice of reinstatement so they know that the casualty policy was reinstated. Should be minimal burden, if any at all. Then the Senate Bill 71 by Senator Smith. This deals with our Louisiana automobile insurance plan, which is our residual market for both personal auto and commercial auto. We have an extremely small residual market. I think probably we range between 50 and 60 policies, both commercial and personal, combined. But what we have now is in the personal side an assignment mechanism, and that is simply proven to be, with that small a policy count, not workable when it's looked at from the direct written premium side, is how we make assignments. We're going to simply change the law and make it be allowed that the plan can issue paper, and it'll be a pooling mechanism. It'll operate better, more efficiently, and the governing committee for the Louisiana Automobile Insurance Plan wanted this to take place. So that's what this bill will accomplish. And Senate Bill 65, this is, Representative Jordan mentioned this. This is the deployment for military service personnel. Mr. Travis on the far end down there, myself, worked on this language. What we're trying to do here is to improve the system whereby military personnel will not have their deployment counted against them when they return and need insurance on their automobile. As it currently stands right now, you have to go through an affidavit process with OMV. We have simplified the process by simply, anybody who's in the military knows you don't do anything, including probably go to a little training, unless you have orders to do that. And that is all I have. I don't know if you want to take questions individually, Crystal? Just, okay.
Hi, Caroline Fletcher, Deputy Commissioner of Financial Solvency. I have 2 bills this session. Oh, okay.
Back up, thank you, Ms.
No, that's it. The first one deals with the ultimate controlling person of an insurance company. It allows a company to appeal to the commissioner when we determine who that person is, and allow the commissioner to make that decision. The second one is our investment bill overhaul, where we are modernizing our investment statutes, which details what investments an insurer can invest in. That's the only two bills I have. Oh, that's
me, I guess. All right. Okay. Tom Travis, I'm the director of the Property and Casualty Insurance Commission. This is a bill that I wrote. It addresses an issue with the Louisiana Insurance Guarantee Association and the definition of a covered claim. And what it would do is exempt from the definition of covered claims any claim by a government entity or by Medicare or a Medicare Advantage plan. And it addresses an issue that's come up in some federal cases on the Medicare Secondary Payer Act. Let's see. Okay. Well, this is another one of mine. This bill, credited for reinsurance, it's HB 247 by Representative Kyle Green. It would update the rules on giving credit for reinsurance. It would address an issue that's come up in recently in Congress. The Treasury Department has signed a covered agreement with the European Union and with the United Kingdom that would allow for a zero collateral for alien reinsurers that meet certain requirements that are domiciled in those jurisdictions. And part of it has to be implemented through state law. And the Model Act has been updated, and we're implementing those updates to the Model Act. And we're creating a new category of reciprocal jurisdiction. And, okay. Who has the, there.
Good morning. I'm Rich Piazza. I'm Chief Actuary at the department. And I have one bill, which they kind of put us in the middle, and I hope, since this is all actuarial, technical actuarial issues, that I'm not going to put you to sleep before you get to the more interesting things that licensing and health have this morning. But this bill by Representative Freeman, HB 682, it deals with the individuals who establish reserves. There are three parts to this. The first one is going to be for the property and casualty insurance company reserves. In this part of the bill, the definition of a qualified actuary for property and casualty statements of opinion is being made consistent with what is now a countrywide standard, beginning with the 2019 annual statement, or the yellow blank. So all we're doing is making our definition in Louisiana consistent with what NAIC and what will become in all states a countrywide standard we expect to become. The second component deals with life insurance company reserves. And this one is kind of, well, I'll try to explain it simply. There are foreign life insurance companies that do business in Louisiana. By foreign, we mean they're domesticated in a state other than Louisiana. And when they come here and want to do business, they have to provide us with a certificate of valuation. What that means is an actuary simply certifies that the reserves this company holds are adequate and reasonable, and this company's not currently insolvent or even close to that. When the company does not have that certificate, the Department of Insurance is supposed to produce it for the company, and we would bill the company for our services, whether we do it internally or we contract out to have that done. This will become a burden because many states, there's a trend, are no longer giving foreign companies that certificate of valuation. In fact, if all companies no longer were given it by their domestic state, we'd have 700 of these certificates of valuation that we would have to produce at the department at great expense and resources. However, there's an alternative, and this is what the change to this statute is going to provide us. Qualified actuaries already, on an annual basis, have to certify the reserves of every company that operates in Louisiana in their annual statement. So instead of having this separate certificate of valuation, what we are going to do is, in lieu of that, rely upon the actuary's statement of opinion that is already mandatory in their annual statement as to the adequacy of their reserves. The third component of this bill deals with life and annuity reserves. We, a number of years ago, passed a legislation that deals with what is called principle-based reserving. And we have a valuation law which deals with the setting of reserves, both on a prescriptive and a principle-based level. What this statute does is simply brings our valuation law up to the NAIC and what is the countrywide standard, so that we are consistent with those standards. And it also is a requirement for our accreditation, so we do need to do this in order to maintain our accreditation going forward. That's it.
That was your 3 parts.
Oh.
No, now you're going wrong.
Going the wrong way. I'm going wrong. See, I don't know how to operate this thing.
Keep going. Now, there you go.
There we go.
License.
It's all yours. Right button.
Barry, you're up.
All right, my name is Barry Ward, and I am the Deputy Commissioner for the Office of Licensing. And in years past, we would have a slate of bills that would potentially impact some, if not everybody in this room, but this year is different. We only have 3, and I doubt that any of these are going to impact anybody in here. But the first one is, let's see if this thing goes.
Right to it, yeah.
Keep going if you want.
One more. There you go.
There you go.
All right, the first one, I have that marked as number 3, but I'll do that first, is a repeal of the requirement for statutory deposits for companies doing business in the state of Louisiana. As it currently stands, if you are a domestic, foreign, or an alien company, that means a company that is domesticated here or licensed here, or foreign being in Texas, Mississippi, or Arkansas, and the alien being in Bermuda or what have you. If you want to do business in the state of Louisiana, you have to have a $100,000 deposit on file for the benefit of all of your policyholders. And that was implemented years and years ago, back when $100,000 was something. But with the more robust solvency requirements and guarantee funds like LIGA, LAHIGA, and what have you, and the workload that it takes to keep track of these things, the decision has been made to repeal this requirement. There will be companies that will have to maintain a deposit because a state other than Louisiana will require that the deposit be held, and in that instance, they will petition the commissioner to hold it, and we will do so for as long as it needs to be held. But it is really something that has, as far as we're concerned, seen its day, and we are doing away with this requirement. The second one is for those of you who sell insurance products for fraternal benefit societies, like Knights of Columbus, Woodmen of the World, Knights of Peter Claver, what have you. Back in 1987, the Fraternal Benefit Code was put into the insurance code, and then it was replaced in 1993, and then it continued on, and then in 2011, the requirement that fraternal benefit society producers was removed erroneously, I think, because of the way that it was done. It was included in a sweep of superfluous language, but it was brought to our attention in the recent past that as it stands, fraternal benefit producers, there is no definitive statement in the code that fraternal benefit producers need to be licensed, and we are just re-implementing this requirement. It is required by the National Association of Insurance Commissioners, and in order to be in step with them, we are re-implementing or replacing that in the code. And then, last but not least, is a repeal of the dental referral plan statute. It was implemented in 1995, and since then we have 2 entities that are licensed as a dental referral plan. And in 2008, a different plan was implemented in the code, that is the discount medical plan. And the language of the discount medical plan is robust enough, sufficient enough. It covers the dental referral plan requirement. So we are going to repeal the dental referral plan requirement, and those two companies will, and one of those two is already licensed as a discount medical plan, but the one remaining will be relicensed or re-registered as a discount medical plan. And that is what licensing has this year.
Oh, consumer services, okay. I'll do that.
Who's that?
That's me. Well, again, I'm going to be stepping in for Jeff Zewe today, the Deputy Commissioner for Consumer Services, who has a couple of bills. Let's see. The first bill is HB 296 by Representative Illig, and it would require a written request for policy cancellations. And this addresses an issue that the Office of Consumer Services has had with verbal communications of cancellations and trying to establish dates and whether or not it's been properly canceled. And next is SB 20 by Senator Gary Smith, and this repeals the life policy search requirement. Currently, the LDI maintains a system for doing life policy searches with life insurers that do business in Louisiana. People go online, they file a request for a policy search, and then we transmit that to the industry. Excuse me. The NAIC in the last few years has developed its own system, and it's a little more thorough system and communicates to more companies than the Louisiana system. So instead of having a duplicate system, we're going to repeal our requirement and just refer people to the NAIC system. And let's see. Well, data security is also mine. And basically what this does, it would implement the NAIC Insurance Data Security Model Law, and which requires, excuse me, it requires licensees to maintain an information security program, to conduct investigations of cybersecurity events, to notify the commissioner within 72 hours of a cybersecurity event, and it provides certain exemptions to licensees with fewer than 10 employees. And it basically takes a corporate governance approach to cybersecurity or data security, because we can't legislate technical standards fast enough to keep up with the changing standards out there. And by the time we get a bill through, whatever the standard was at the beginning of a legislative session, it would probably change by the end of a legislative session. And so that this is the approach that the NAIC has taken on the issue of data security.
Okay. Good morning, everybody. Frank Opelka, Deputy Commissioner for Office of Health, Life, and Annuity. The first bill we have of the 8 total is Senate Bill 213 by Senator Cathy. This bill will implement medical necessity standards for substance use disorders. Louisiana law doesn't currently define placement standards or placement criteria for SUDs. This would implement the ASAM criteria, the American Society of Addiction Medicine criteria. This essentially is about determining which level of care a person needs when they need treatment for a substance use disorder. Do they need to go inpatient? Should that inpatient be a rehab facility? Do they need outpatient? Is that outpatient a facility-based outpatient or home-based? There was an insurer that had developed its own standards to determine that level of care question, and it was kind of significantly out of line with the standard in the industry, in the health industry, and was resulting in coverage declinations in cases of substance use that were inappropriate. There was a class action case that was brought related to this topic, and ultimately the insurer lost that case on the basis of federal law and 4 state laws. Louisiana was not one of the 4 states that has that law, so we're replicating that here. Essentially, we're creating a state right of action where otherwise they would have to go to federal court. Direction. The next bill is Senate Bill 174 by Senator Bernard. This is a broad revision of references to the Affordable Care Act. Throughout our code, we have several places where we refer to the ACA in a way that if the ACA were changed, repealed, overturned, any of the above, those references would become nonsensical. And in some cases, it creates some significant problems. One example is there's an authorization for an insurer to cancel coverage on the basis of the member committing fraud. That reference says fraud as permitted by the ACA. So if the ACA were overturned or repealed, that section would no longer permit an insurer to cancel coverage on the basis of fraud. So this corrects that sort of issue. The intent of the way we've drafted that bill is to not make substantive changes. So we're just making changes to the reference while preserving what the law actually does. The next bill is Senate Bill 216 by Senator Cathy. This is essentially a technical bill. A few decades ago, we split the life and annuities licenses, and in most cases, we refer now to life and annuity in the code separately, but there's a few places where we continue to refer to just life. Previously, they were referred to as a collective. Now we're adding annuity language into those sections. The interpretation is already that it applies to annuities, but this adds the explicit reference. And then Senate Bill 90 by Senator Fazy is also a technical change. There is currently a requirement for written notice prior to lapse of a life policy for non-payment. There's 2 exceptions to that. One of those exceptions is found in the body of the requirement, another is found in an exception section. We're just moving the exception from the body into the exception, so they'll both be together. Senate Bill 47 by Senator Robert Mills is a revision to our funeral cost reservation permission in group life. So this last was updated in 1981. It permits the policyholder to reserve up to $250 to cover or to give to somebody who's covered your last expenses and funeral benefits on your behalf. We're increasing that permission to $2,500. So if the policyholder and the insurer agree, they can reserve up to $2,500 to help defray the cost of whomever paid your funeral benefit. There's also a technical revision in there. Senate Bill 148 by Chairman Talbot is our 1332 reinsurance waiver bill. So if you remember a few years ago, we brought a pair of bills, one to give us authority to seek a 1332 waiver and the other to create kind of the meat of what that waiver would look like, the reinsurance program itself. The authority passed, and that's in law, but the meat of what the reinsurance program would look like wound up failing on a tie vote in the Senate after having moved through the process. So we've essentially picked that bill up where it ended. The language largely reflects the language that the bill had when it got to the end of the process, and we're going to pursue that again this year. So it's funded through a fee on all health policies statewide in the amount of $2.50, and that's a cap, so we can charge less if we need to. And under the analysis we had previously, we would need about half of that to get to the premium reductions target of the program. I've run some rough numbers in preparation for this bill moving. It looks like the state would need to contribute roughly $30 million to fund the program. That would generate a federal fund of approximately $100 million annually, for a total of $130 million that would go to subsidize the individual market through a reinsurance program. And the essential upshot of that is premiums in that market would fall by approximately 15%. The purpose of that is to make the market more appealing to people who've left, and also to insurers who currently don't have really the ability to enter that market because it's shrunk so much. Currently, there's 12 states that have run reinsurance waiver programs that are essentially identical to this, and they currently are up and running. They've largely been extraordinarily successful. Colorado did one a few years ago, and I think they achieved a premium reduction of about 20%. There's 2 more that are pending. Then the 7th bill is Chairman Talbot's Senate Bill 231. This is essentially a revival of the high-risk pool that existed in Louisiana pre-ACA. The purpose of it is, if the ACA were to go away or to be changed in a way that no longer protects pre-existing conditions, we need some kind of program in place that would protect those individuals who could otherwise be harmed. Before the ACA, we had this program. It was very functional. It protected a few thousand people in the state who had pre-existing conditions. It was largely funded through a hospital bed fee that was essentially a pass-through, so the hospitals weren't taxed. It was actually insurance companies that were paying it. This would just revive that, and it would revive it only in the case where pre-existing condition protections in the ACA are essentially rendered inert. So it doesn't revive it and start charging any kind of fee if the ACA is still functioning to protect those same people. Oh, I'm sorry. Let's see.
He's going forward now. He's going forward.
Okay. So that was the first one. And the second. And the final bill is, so this actually is more of a to be determined. There are 2 surprise billing bills moving through the process right now. I think our intent is to work on both of them and try to get them into a form that protects consumers while also avoiding increasing premiums, so that the market remains stable. This is a long-term process, or a long-term problem that I think has grown in the public consciousness over the last few years, especially as we've seen a lot of sort of egregious air ambulance bills, where you're seeing people that are getting billed $30,000 and $40,000 for an air ambulance ride that they had no idea would cost them anything. The overall intent of the bills that are out there right now is to follow one of 2 models, which are kind of the core models that exist in surprise billing. One is to do an arbitration-based model where surprise billing is resolved through usually a baseball-style arbitration. So the physician and the insurer both propose an amount, and the arbitrator picks one amount or the other. He doesn't substitute his own judgment. The other is the other model that's commonly seen, which is a reference-based amount. So that style starts by saying balance billing is prohibited. Then the insurer and the provider have to kind of come to terms on how much the provider is going to be paid, and he must be paid at some threshold. So a lot of times they'll say he must be paid at 150% of Medicare, he must be paid at some percentage of median in-network rate, or some other reference. That's always a difficult determination to make because you don't want to give too much power to either side and, you know, undo the competition in the market. So choosing a reference point that isn't under the control of either side is very important in that process. And those are the health bills.
First of all, would you give the staff a round of applause? I'm told we have a brief 5 minutes for questions. Anybody have questions? We've got somebody in the back.
Yes, my question is for Mr. Travis. The bill that you referenced earlier about the LIGA payments that would be exempted from reimbursements for Medicare or Medicaid, it seems like it would be a conflict with the Medicare Secondary Payer Act. Is there any part of that statute that would allow you to basically say LIGA doesn't have to pay those amounts?
Well, there's a federal court case, California Insurance Guarantee Association versus Azar, that came out last summer, and that's what gave me the idea for this bill. And the Ninth Circuit found that because California had an exclusion for government entities and for Medicare, I think it was, theirs was a government entity exclusion only, and the court found there was a 20-page opinion going through McCarran-Ferguson Act and reverse preemption under McCarran-Ferguson, and they held in favor of the California Guarantee Association.
In the back.
Oh, come on. Will's going to ask me a question.
Representative Jordan, thank you very much. Will Grubbs from New Iberia. Has your committee, will your committee review the part of tort reform where it deals with the collateral source, in particular in House Bill 9, as well as others trying to amend RS 9:2800.25, and try to study the impact it will have on the hospitals, where this bill is trying to say that hospitals have to take what Medicare pays?
Yeah, well, we're going to look at everything now. And let me say this: that bill may be, depending on what the speaker does, it may be referred to more than one committee. But I'm sure we are going to take a look at that, and we have spoken with some healthcare providers who have some of those same concerns that you have.
Thank you, sir.
Oh, in the corner over here. Oh, got one here. We have a lady in the corner next. Go ahead.
For Representative Jordan, do you have an opinion on which direction that you would lean towards on the surprise billing issue?
You know what? I don't have an opinion right just yet, but I can tell you when it goes to committee, we're going to study it thoroughly. So I don't have one yet, but we're going to certainly flesh it out in committee and have a real good discussion on it.
I had a couple of questions. One's just kind of a technical thing. Whoever had talked about the bill about the notice of going out to the same people, I know you were talking about homeowners, but the slide said all business. Is that like the slide said, or did I misread it, or is it just homeowners?
No, it'll be for all businesses,
Okay.
any property and casualty policy.
And then I had a question on CBA's bill on data security. Is that going to, in the language of the bill, is that going to extend to third parties? In other words, as a small agency, are we going to be responsible or could be penalized if we can't get some major system in place responsible for the people that we are saying? I mean, because we send data out to a lot of different people in the process of insurance. Is that going to have some limitations on what we're responsible for?
Well, currently, the bill is introduced is the NAIC model, which does have responsibility for third-party service providers. And a lot of people have addressed that issue with us, and so we'll have to discuss that.
Okay, so you're still working on that part?
Right, we'll have to look at what some of the other states have done.
And then I had one last thing for Representative Jordan. And this is more a comment. I'd like to hear your response. stepping away from the insurance, my role in the insurance industry, just my role as a consumer purchasing insurance, I'm understanding that insurance is a shared risk, and I understand that my premiums would be based on certain factors of my risk to the insurance company. You use the word subsidy. I have never, as a consumer, considered my premium to be a part of subsidizing other people's risk. And I'd just like your comment on that.
Well, because it is a shared risk, but so when we say, and I'm using the word subsidy, and you're technically correct, but when we're talking about a shared risk, we're talking about a pool, and we're talking about how premiums are set in claims. So from my perspective, I look at it like this. When it's based on factors that you can control to a certain degree, then, and that they're relevant, then I think that's fine. I don't necessarily think that your zip code, your credit score, whether you're single or widowed, whether you've been deployed to the military, really has anything to do with what your insurance rate should be. I think it really should be based on the fact of whether you're a good driver or a bad driver. How many tickets you have, how many accidents you've caused, and then that followed that. I think those are the things that we need to look at. And so my only thing is this. We're creating factors, in my opinion, we're creating factors that may have some correlation, but not necessarily a causation with accidents and how you drive. And so when we're looking at those factors, we're keeping people out of the market that may otherwise be able to afford it. And so what happens is, what you're doing is you're reducing the people that can share that risk with you. Now, whether you call that subsidy or whatever, we can get into semantics. But the fact is, you're keeping people that might be good drivers, that could pay into the system to share that risk with you. We're basically pricing them out of the market. So we have to do something to bring these people into the market so that we can have more people sharing the risk and more funds there to share the risk. So that's my only point on that.
Thank you very much, Mr. Vice Chairman, and I truly look for, indeed. I truly look forward to working with you for the next 4 years on insurance matters. I served for 10 years on the insurance committee back in the 90s with similar but different challenges, and it was always very stimulating, and is why I'm still doing it here today, because of the challenge it represents and the importance it has. And I will, in the interest of getting us out on time, limit myself, which most of you know is very difficult for me to do, but to just a couple of closing comments. First off, I would ask everyone to remember to sign the back of your badge and return it before leaving in order to earn your CE credits. There'll be baskets at both ends of the hallway outside of the room for you to just throw those in there. For those of you like myself, although I'm old enough to not need continuing legal education any longer, but those of you young enough to still have that burden, you must write your bar number and sign the back of your card when you throw it into the baskets. The PowerPoints, as we have said before, will be available by the end of next week on all presenters who were here today, and some of those are worth a look when they are put up on our website and made available to you. Last bit of bookkeeping or information specific to the meeting and to the CE credits. The last secret word is beignets. So please note that and finish up. I can't tell you how much I appreciate the feedback. Oh, wait, there is one other. Thank you. There is one other. By the end of next week also, we will be sending you electronically a survey. on your thoughts of the day-and-a-half presentation and the different approach, different focus that we had here this time than in the past. Truly would appreciate your input. I've gotten a lot of it from folks as I've been walking around yesterday and today. It's been positive, but if you have suggestions or even criticisms, please share those with us. 6. You have what? Oh, that's right.